Number two, my lords, the judge held that the paragraphs I've taken my lords through were obiter dicta. So what previously to us as legal advisors were the controlling authority, now the High Court said those were obiter dicta, they were not binding, and all the candidates in the invalidated election have a constitutional right to participate in the fresh presidential election. That took place the day after abandonment. What does this mean? This means, my lords, that another judicial pronouncement became the regulating authority. It regulated the period from 11th of October. It had to be implemented, and what IBC did, and they cannot be faulted for doing that, was to now allow another Gazette notice to be published in which they had the names of 5 candidates. The only omitted candidate was one of the candidates because he had a legal impediment, and that legal impediment, my lords, is common ground. As soon as that legal impediment was again suspended by the High Court, that candidate was put, there was another Gazette notice. So, my lords, as to the question, what was the guiding law regarding the conduct of this election, there are those 2 cases, those 2 judgments, each from 1st September to 10th, no, not 1st September to 10th October, then from 11th October up to the time of the fresh presidential election. 2 judgments each operating within that period of time. My lords, can IBC be faulted? In my submission, they cannot be faulted. They obeyed the law as set out in the 2 judgments. And my lords will notice that the political participants in the contest, none of them ever challenged those positions, because in my submission, those positions reflected the correct position in law. Therefore, my lords, as regards this question, which I posed right from the word go, what was the law that regulated this election? The law was the 2 judgments, each operating at a certain period in time. I go back to the